Okay, we'll start off with the United States Constitution, the Fourth Amendment, and the relevant paragraph of the New Jersey Constitution of 1947. I did a little bit of research. This provision of our state constitution, which is now codified at Article 1, Paragraph 7, actually has been part of the fabric of our constitutional law since 1844. We've had three constitutions in the history of our state: 1776, 1844, and the 1947 one. So well before Mapp versus Ohio, more than, 120 years before Mapp versus Ohio, we were making the provisions of the Fourth Amendment applicable to our states. All right, and you'll see that there's only one type of search, either under the state constitution or the federal constitution, that is barred, and that is a
unreasonable one.
Oh, what's an unreasonable search, Unc?
He's
my uncle on top of everything else.
One that does not take place with a warrant.
Okay, so the key thing for you to remember, you're going to find over and over and over again that the exceptions we're going to be talking about, when they're interpreted by our appellate division and by the Supreme Court, our courts will find enhanced protection under the state constitution, much more so than you would get under the United States Constitution. And of course, we'll highlight that as we go through these exceptions today. The key thing to remember is that you think about the Fourth Amendment to the United States Constitution as a floor as opposed to a ceiling. In other words, it's the minimum amount of protection that you can get in our country. States under our system of federalism are permitted under their own state constitution to provide more protection, and that happens all the time in New Jersey, and you'll see that in the various exceptions we're going to be talking about. Okay, so foundational issues to go through. Only one type of search prohibited, as Bill just said, is an unreasonable search. There's really two aspects to this reasonableness that I wanted to talk about very briefly. First of all, as Bill indicated, searches that are undertaken pursuant to judicial authority in the form of a search warrant are presumed to be reasonable searches, okay? And when you have a search that's undertaken under the authority of a warrant, typically the burden of challenging that is going to be on the defendant, and the defendant's going to have the burden of production and the burden of persuasion on showing that the warrant was improvidently granted, or that, let's say, the only other exception to that would be is it was like police went in without knocking and announcing and didn't have the authority to do that under the warrant. But just generally speaking, a warrant that's issued under judicial authority is going to be presumed to be reasonable. By contrast, searches that take place without the authority of a warrant are presumed to be unreasonable, and it'll be the responsibility of the prosecutor to show that the search fits within one of the recognized exceptions to the warrant requirement. All these exceptions are given to us by the Supreme Court, and so we'll be talking about each one of those today as we go through the materials. Go backwards for a second, though, Johnny, because I want to point out one thing. On number 2, there's a second reasonableness requirement for the police, and that deals with the way the police go about conducting the search, all right? Police are required to act reasonably during the conduct of a search or a seizure. So that doesn't matter whether either with a warrant or without a warrant. They still have to act reasonably under those circumstances. So you're going to see cases that will come up today where the police were acting within the confines of an exception to the warrant requirement, which otherwise would have excused their conduct or made their conduct justifiable or reasonable. But it's the techniques that they utilized in executing the search or seizure that was unreasonable, and that's what led to the suppression of the evidence. So keep that in mind, all right? These exceptions to the warrant requirement we're going to talk about, by the way, all come from the United States Supreme Court. So the way we have your materials set up today is as follows. You'll have the original case that establishes the exception to the warrant requirement, some explanation about how it's supposed to apply, and then the New Jersey view of it, where the appellate division or the Supreme Court will discuss it and determine whether or not it's going to be viewed expansively in New Jersey or in conformity with what the Supreme Court said. All right, Johnny? All right, substantive and procedural issues. We talked about enhanced protections under the state constitution. Typically, when you're doing a motion to suppress evidence, the burden on the state is going to be to show that the exception fits within, or the search fits within one of the exceptions to the warrant requirement, and the burden of proof is going to be the simple standard of proof by preponderance of the evidence. Now, there are 3 exceptions to this that I want you to put down in your notes, because the state will have an enhanced burden when you're utilizing these 3 exceptions to the warrant requirement. They are searches that are done by way of consent, searches involving a theory of inevitable discovery, and searches where the state relies upon the collateral source rule. All three of those have an enhanced burden of proof, which is clear and convincing evidence. Apart from that, every other exception to the warrant requirement, the burden of proof is going to be by preponderance of the evidence. All right? The burden of production, of course, is always going to be on the state when you're dealing with a warrantless search, and since these are all exceptions to the warrant requirement dealing with warrantless searches, the burden on all of these is going to be on the state. Okay? We talked about the objective reasonableness as a justification for police actions, but Bill, can we talk about that, what we mean when we talk about objective reasonableness?
Yeah, the Supreme Court has always said that it doesn't make any difference what a police officer may or may not have thought he or she was doing at the time that they're doing it in regard to the Fourth Amendment. The issue is a simple one, and that is whether or not the action that was taken by the police, whatever the motivation of the individual officer may have been, was objectively reasonable. And so you have to keep in mind that we operate in the Fourth Amendment always on the basis of whether the action that was taken by the police was objectively reasonable or not. So a police officer theoretically could act out of the worst possible motives, but as long as the actual actions that were taken meets the requirements of objective reasonableness, then it will meet the requirements of the Fourth Amendment.
A tremendous advantage for the prosecutor, because if the police officer thought he was doing X, Y, Z, and X, Y, Z is not recognized as an exception to the warrant requirement, it doesn't make any difference. As long as the prosecutor can find some other exception to the warrant requirement that fits the facts and is viewed to be an exception, and the actions of the officer are otherwise reasonable, the state should win. Let me give you an example of how this came out. There's a case, one of your favorites, State versus Ireland. It's Ireland, leave the last D off for drunk driver. And in the Ireland case, like these drunk young men, they do everything they can to attract the attention of the cops, and this is what these fellows were doing. Driving crazy on the Atlantic City Expressway. Basically, they should have had a big sign over the car with an arrow saying, "Attention police, stop me," So the police wind up stopping them. There's a passenger in the vehicle who they excuse very quickly after they clear him through NCIC, but the driver appears to be under the influence of alcohol. So they arrest him and radio back to the police station, "We're going to conduct a search incident 2, meaning we're going to search the vehicle incident to the arrest." And they search the vehicle, and they find a handgun inside the vehicle. This is down in Atlantic County. So what the troopers were not aware of at the time was that the search incident to arrest and exception to the warrant requirement, at least as far as New Jersey was concerned, had been excised. It was not recognized under our state constitution anymore. So there was no constitutional basis for the troopers to have conducted a search incident to an arrest. But it doesn't matter what the troopers thought they were doing, because there was another exception to the warrant requirement which justified their conduct. In this case, it was the automobile exception. In other words, the Appellate Division found that the police had ample probable cause to arrest this guy. They also found that the troopers had probable cause to believe that there were implements of drunk driving hidden inside of the vehicle. With this broad rule that anytime the police arrest somebody for drunk driving, that gives them probable cause to believe that inside the vehicle you'll find beer cans or little bottles of vodka or whatever it is that drunk people have inside of their vehicle. All the police had to do was justify their search of the vehicle by showing there were exigent circumstances which would tend to excuse getting a warrant, and they found plenty of exigent circumstances for the vehicle that had just been pulled off of the Atlantic City Expressway. So I point this out to you to show you how it didn't matter what the troopers were thinking. There was another exception to the warrant requirement which justified their actions. That's what we mean when we talk about this objective reasonableness, which is a big, big deal for the state. Totality of the circumstances test is another important thing for prosecutors to know about, meaning that the courts are not going to judge these things in isolation, but on the totality of everything that was presented to the officer, which, when you're dealing with police actions, includes the specialized training and experience that law enforcement officers have.